organisation and motivation and enthusiasm for this. However, I think she's got a character trait which we ought to question. to inflict, just one I'm going to mention, to inflict law on you at 4 o'clock on a Saturday afternoon. Hello, this has got a life of its own now. To inflict law on you at 4 o'clock on a Saturday afternoon suggests either a warped sense of humour or a rather disturbing sadomasochistic tendency. But you can talk about that over dinner. We're taking on a bit of a religious tone here. James started to talk about his epiphany this morning, and I'm calling this the Holy Trinity. I should apologise to any of you who are doing the MSc Animal Welfare course, who may in 3 or 4 weeks' time recognise some of these slides, but they're in a different order, so it's a different presentation. And in education, we call it, I can't even remember what we do call it now. We call it something. Anyway, the Holy Trinity, or to put it another way, why we're all in this together. And this is a serious point. We are all in this together. We've all got a contribution to make, and that contribution will last beyond all our lifetimes. Clearly mine, because it's nearly done, but yours as well, because the issue of animal welfare will continue to go on. Because one of the peculiar traits of humanity is when you address one issue, 2 new ones come along, which tend to be even more complicated than the first one. And the Holy Trinity reinforcement, that's the word. In education, we call repetition reinforcement. So I get there in the end. Lateral thinking. So the Holy Trinity is this. It's animal welfare science, animal welfare ethics, and animal welfare law. The 3 go together. None is as effective on its own as it is with the other 2. And this is the way it works. That science, which is the basis of the whole thing, provides the evidence-based understanding of other species' capacities, their needs, their state, their quality of life, and the impact of human use and human relationships with them. So science provides the evidence. Ethics provides the argument, because in the light of the evidence that science provides, ethics gives us the basis to consider how we ought to be treating these other species. Moral, ethical questions are always ought questions. How ought one to behave? And the third in the trio is the law, because the law provides state-imposed regulation specifying how other species ought to be treated. And the 3 together make up public policy on animal welfare. And it's this notion of policy which is important. What is law? I'll talk about that shortly. But at basic, it is policy, it's public policy, which has been turned into something which is binding and which can be imposed by the state through the courts. Now, there's ethics and there's ethics. There's professional ethics, which is what we've been talking about mostly today, but there are, of course, wider ethics in society, social ethics. And as far as animals are concerned, an ethical debate about animals, what you do with your professional ethics should have a profound impact on social ethics, on the wider view which society takes of animals, because you are the best informed people. You are the people with the legitimacy, the credibility to put forward the arguments. And that is why it is so important, whether you are acting individually as a practitioner in your consult room or collectively through your organisations like the BVA, like the Animal Welfare Foundation, like the other multitude of veterinary organisations there are. It's absolutely essential that you play your role to try and influence public policy on animal welfare, because I was going to say you're the experts. That's not strictly true. It's going in the right direction. When I started in animal welfare about early 90s, I suppose, nearly 30 years ago. Do you know, because of course in Scotland, bright students can come to university when they're 17. It absolutely shocked me when a couple of weeks ago when I got records for my first year advisees and they'd been born in 2000. I was already old in 2000, for God's sake. Anyway, it is really important. It is really important because, as I say, you have the legitimacy, the credibility, the authority. And what I was going to say, when I started this, I used to really upset veterinary audiences, and it actually shows how far things have moved on by going in and quite deliberately saying, you know what? Not all experts on animal welfare are vets, and not all vets are experts in animal welfare. And they used to really take that quite personally. It is still true, of course, but I think it's moving in the right direction. It is a generational thing. It's a generational thing that attitudes to animals within the profession and to ethics and to welfare and welfare science is moving in the right direction, largely because the old farts are dying. And that is true. That is absolutely true. I mean, it is amazing. It is amazing how far the veterinary profession has come in, 20 years? Which I know to you is a lifetime, but 20 years is the blink of an eyelid. And when you think how little it actually progressed for most of its history, and in the last 20, 30 years, not just in terms of what it can do, maybe it can do too much, but in terms of attitude and debate. It used to be a much more mechanical thing. I mean, James can remember, Emma can, no doubt Paula can, when issues weren't really talked about at all, because issues was just waffle, wasn't it? It was what you could do with your hands that mattered. So this is the interplay between professional ethics and the ethics of wider ethics of society is important. And of course, it's the science which influences those ethics, because, as I say, it is the science which produces the evidence. And right from the beginning, actually, it's science which has played the key role. Up until late 18th century, the attitude in Europe generally and Britain in particular was simply that there was no direct moral duty towards other species. Of course, individuals may have felt differently, but that was the public view. That was public policy. It really didn't matter how you treated other species, partly because religious teaching told us that they were all there for our benefit and we had dominion over them and we could do what the hell we liked with them. Secondly, because they were people's property, something I will come back to, and like every other item of property, generally owned by a man, he could do with it what he wanted, including, of course, his children and his wife. So, and this cartoon I've put up is a cartoon by Hogarth, 18th century cartoon, which demonstrates the sort of things that were going on in London at the time. Right at the back there's a bit of bull baiting and bullfighting going on. Coming forward, there's an overloaded donkey. Then there's a poor old horse. Then there's some sheep being driven. And the point he's making, there's a message here, the point he's making is that this carriage on the left-hand side as you look at it is, the horse is clearly collapsed from exhaustion, and the point he is making is that the passengers in the carriage are barristers on their way to the Inns of Court in London. And he's making the point it really is time that there was law to protect these animals. And it was the combination of scientific research in the 18th century during the Enlightenment, not least vivisection carried out on live animals such as this, which led people to realize what would seem to us to be common sense now, that if these other species had the same organs, apparently carrying on the same functions, then just maybe they were sentient, unlike Descartes, who of course equated any sort of sign of pain with the chiming of a clock and regarded animals as automata. And it was the combination of this scientific realization that other species could feel pain, coinciding with old Jeremy Bentham, still in his box in University College London. That's right, you always get a bit of audience participation. With Jeremy Bentham coming along with utilitarianism, which was absolutely a game changer. Introduce you to two game changers. This was one of them, because up until this point, the assumption had been, or the emphasis had been, on the differences between humans and other species. We were created in the image of God. We had a personal relationship with God. We had a soul. We had eternal life. We had speech. We had rationality, all of which, it was said, other species didn't have. And the whole emphasis was on this unbridgeable gap between us and them being provided by God for us to exploit. What happens with Bentham is he comes up with utilitarianism, the greatest happiness for the greatest number. He has to have a good criterion and a bad criterion. The bad criterion he chooses as pain. That coincides with scientific understanding that other species could feel pain. Suddenly we had a criterion of shared experience. And Bentham saw the light bulb flashed, because he could see that if utilitarianism was a philosophy based on interests, and the crucial criteria extended beyond humans, then the interests of other species should be taken into account. Hence the famous quotation, notwithstanding that it's actually only a footnote in the book. So as students, here's something to learn, always look at the footnotes. The question is not can they reason, nor can they talk, but can they suffer? And that led directly to the first legislation in England in 1822 and subsequently in Scotland in 1850, with the emphasis being on cruelty, which developed through the courts into the notion of unnecessary suffering. And what is so important about the first legislation, and if you come from other countries or you're going off talking in other countries that don't have any animal protection legislation, the first piece of legislation is always the most important. Why? Because it establishes the legitimacy of the state intervening to protect animals, and in so doing restricting the autonomy of their owners to do with those animals whatever they want. It's a hugely, hugely important and profound principle. And of course, going back to ethics, attitudes to the treatment of animals and how we use them change over time. Essentially, activities involving animals fall into one of two groups. On the one hand, there are those activities which are considered to be illegitimate and which hopefully the law steps in to ban. And then there are the activities which are society considers to be legitimate, which are, by and large, to a greater or lesser extent, regulated by the state. Historically, the state has not banned very much. The first thing it did ban was animal fighting and baiting in England in 1835, in Scotland in 1850. But not much else has been banned until relatively recently. And here we can see the influence of changing social attitudes, which are being influenced by a change in the way that other species are viewed, and that change, I would suggest, is being promoted because of the science. So, for example, fur farming, something which was considered entirely legitimate by most of the population, banned in England in 2000 and Scotland in 2002. Hunting with hounds, not banned, I should say, still perfectly lawful to use hounds to flush quarry out from undergrowth, but it is illegal to allow the hounds, or to intend to allow the hounds, to hunt the quarry. Something which was not only considered acceptable, but if you go back to Victorian literature, Trollope and the rest of it, was really deeply embedded in aristocratic society. And of course, Emma's already talked about it, docking of dogs' tails. And I was talking to Emma at lunch and saying, it shows not only that it could be done, notwithstanding the rather regrettable reversal by the Scottish government, it's not only showing that it can be done, but how quickly has it come about that you see dogs of types which were previously banned, which were previously docked. Now with tails, the world has not come to an end. Life has gone on. The only difference is the dogs now have tails to wag and look the better for it. And something which is just on the cusp is the use of wild animals in circuses. There's a bill before the Scottish Parliament at the moment which will ban it, and hopefully Wales, England and Northern Ireland will catch up in the fullness of time. So attitudes do change, and changing social attitudes have a direct impact on the law. Now, as I say, for the majority of our time since 1822 in England, 1850 in Scotland, the law has prohibited cruelty, which is interpreted as unnecessary suffering. And although there has been other legislation, it hasn't actually done that much up until the late 1960s. I should just say about the offence of cruelty and unnecessary suffering is that it is an essential offence. I'm not belittling it in any way. And again, if you're dealing with a country that doesn't have animal protection legislation, yes, we would like welfare, please, but if you can't get anything else, go for cruelty, because at least it does something and makes people accountable for the treatment of animals. So it's essential, but it is not in itself complete. Why? First of all, it is negative in character. It says what you can't do. You can't cause an animal unnecessary suffering, but it doesn't impose any positive duties. Secondly, the focus is entirely on suffering. And an animal's state can be inadequate, unsatisfactory, without it suffering. Moreover, because of the burden of proof, criminal offence has to be proved beyond reasonable doubt. And given that the majority of cruelty prosecutions are not for deliberate cruelty, but for negligence, enforcers, and the SSPCA know this only too well, enforcers can end up in the absurd situation if the owner does not comply with them prior to the Animal Welfare Act of 2006. Enforcers were left on the sidelines waiting for an animal's condition to deteriorate to such a poor state that, because clearly with negligence they tend to deteriorate over a period of time, enforcers used to end up standing on the sidelines waiting for an animal's condition to deteriorate to such a bad extent that they were satisfied they could demonstrate beyond reasonable doubt that it had actually suffered. That is not animal protection legislation, that is holding the abusers to account after the event. And that's the fourth point. It is entirely retrospective. So it is essential in itself, but it is not in itself sufficient. What one also needs is something to complement it. Law which imposes positive responsibilities. Law which focuses not just on suffering, but on promoting a good quality of life, that is prospective and therefore allows early intervention to put things right or get the animal out of that situation. And that is precisely what animal welfare legislation is intended to do. It goes back to the 1960s. They do still talk about bramble in vet schools, don't they? Good. Do they read the report? Probably not. No. Good. Well, some of you may have heard of bramble, some of you may not. The thing was that after the Second World War, intensive farming was introduced, but intensive farming tends to go on in buildings, so people weren't aware of what was going on. Two things happened very close to one another. One was that a wonderful woman called Ruth Harrison wrote this book, Animal Machines, which was published in 1965, which was an academic, evidence-based expose of factory farming. And secondly, the Sunday Times magazine, which was the first colour supplement in the UK, in a very early edition, produced a photo expose of what was going on. The problem was, you see, the only legislation there was at that time was unnecessary suffering. And there were two problems. One was that, and this shows how far the science has advanced actually, the assumption was that if an animal was producing whatever it was being kept to produce, then everything was okay. That was essentially the assessment of its condition. And second, so all these animals in intensive farming methods were producing whatever they were being kept to produce, so it was assumed that it was okay. Even if it had been possible to demonstrate that everything wasn't okay, then it had been government policy to increase food production in the UK, because it wasn't the Luftwaffe that nearly did us it wasn't the bombing of the cities that nearly did the UK in the Second World War, it was the U-boats in the Atlantic, because they were cutting off the food supplies from the United States. So it was government policy to increase food production. Therefore, if it had been possible to demonstrate that there was suffering, it would undoubtedly have been regarded as necessary suffering. There was a hoo-ha in the press about all this, and the government did what governments tend to do when they think they should do something, but they're not quite sure what. They set up a committee of inquiry. And Whitehall's shelves are full of committees of inquiry which were worthy but did not make one iota of difference. This did. This is the second game changer. And anybody who's looking at animal welfare should read the first chapters of the Bramble report. It's not widely available. I'm sure there's one in the library here. I have an electronic copy of it, which I would be only too happy to send to anybody who emails me who wants it. It's a wonderful, wonderful, it is a game changer. It really is a revolutionary piece of writing. And it led to the first mention of welfare in legislation. This is the old boy, doesn't look a load of laughs. Only picture I've been able to find it looks as though he's doing his Hitler imitation there. He was professor of zoology at Bangor, I think it was, But no one was quite sure what welfare was, so he has to ask, and these are quotations from the Bramble report. Welfare is a wide term that embraces both the physical and mental well-being of the animal. It's not just about suffering, it's about well-being. Any attempt to evaluate welfare, therefore, must take into account the scientific evidence, here we go, available concerning the feelings of animals. Now, any serious scientist who talked about the feelings of animals in 1965 was just regarded as some sort of anthropomorphic wimp. But here we are in the official report. The feelings of animals, that can be derived from their structure and functions and also from their behavior. This was really revolutionary stuff. And he goes on, we are concerned with the welfare of the animal throughout what may be the duration of its life. We consider that it is morally incumbent, here come the ethics, morally incumbent upon us to give the animal the benefit of the doubt. Public policy is not quite caught up with that yet. To give the animal the benefit of the doubt as far as possible from conditions that may be reasonably supposed to cause it suffering, even though this cannot be proved. And this is where he turns the assumptions of the time, the orthodoxy, on its head. Many witnesses have represented to us that the growth rate of an animal for meat or the egg production of a laying hen are the only reliable objective measures of their welfare. It is claimed that suffering of any kind is reflected by a corresponding fall in productivity. The argument is that in the absence of any scientific method of evaluating whether an animal is suffering, its continued productivity should be taken as decisive evidence that it is not. And they sweep that away in a sentence. This is an oversimplified and incomplete view, and we reject it. God bless them. Modern intensive animal production methods most markedly increase the responsibility of those who use them towards the animals in their charge. If any creature is wholly and continuously under control, we believe that this total human responsibility must be acknowledged. So here we have it, a report focusing on the feelings, the behavior of animals, talking about welfare being an ongoing, life-existing issue, of imposing responsibility on those who care for animals. And that led straight to the 5 freedoms, which I know are a bit dated now, but it also developed it led to the development of animal welfare science. You are all here, we are all here, because of Bramble. Because once this term welfare was used in legislation, ministers needed to know what it meant in real life. And that led to the establishment of an advisory committee, and the advisory committee needed the evidence to put before ministers, and that led to the discrete discipline of animal welfare science that we have now. And old Bramble was there before us. We recognise, he says in the report, that the scientific information available concerning the behaviour of domestic animals is inadequate in many respects. This is a field of scientific research which has not attracted the attention which it deserves, and that opportunities should be sought to encourage its development. It's a pity he couldn't be here at a meeting like this to see what has happened. Now, this is clearly a simplistic view of the world, but there is an element of truth in it. You start with the scientific research. That's the basis of the whole thing. That gives us the insight and understanding into what we're doing with animals. That changes the ethical debate, feeds into public opinion through the media, but particularly through NGOs. That influences public policy, which then gets through to Parliament, influences regulation, and so it goes on. And you know what? Bramble was there too. It appears to us, he's writing in 1965, reasonable to anticipate a continuing development of concern for animal welfare, and that conditions which appear to us tolerable today may come to be considered intolerable in the future. Now, the nature of law, and I'm conscious of the time, but law if there's one message to get over, you're all involved in law in one way or another. There's nothing to be frightened about it. All it is public policy which has been endorsed by Parliament and put into a form which is enforceable. It is very different from science. Science is international. Science is apolitical. The way science is applied may be political, but the thing itself is apolitical. Law is jurisdictional. The jurisdiction can vary. It is political for two reasons. One, it clearly reflects value judgments, and secondly, in liberal democracies, most law is passed by legislatures made up of elected politicians. And elected politicians are going to make political judgments in what they're prepared to support and to sponsor. Most animal welfare legislation is national rather than international, subject to which side of the line you put EU law. And to show you how different law is from science, we'll take the meaning of the word animal. Here's a definition which, yes, I'll admit it, I got off Wikipedia, but I've shown it to other audiences, scientists, and although there may be a bit of controversy around the edge, most scientists seem to think that, by and large, it's sort of something they could agree to. So you could come to a definition of what an animal is in science. In law, I'm afraid all I can do is give you a quotation by Lewis Carroll, the famous Humpty Dumpty one, because animal can mean whatever the draftsman wants it to mean. There's a law, and if you're ever looking at legislation, it'll witter on about animals, always look for the definition in that particular context. Legislation requiring boarding kennels to be licensed by a local authority talks about animals. When you get to the end, it's just a dog or a cat. Zoo Licensing Act, which does what it says on the tin, again, throughout talks about animals. When you get to the definition, it's so wide it's practically anything which is animate but not a plant. And sometimes the bastards really trick you by changing the definition halfway through. But what I'm saying is law is completely different. In exactly the same way, poor old Don Broome at Cambridge, under the old 1911-1912 Animals Protection Act, had a wonderful definition at the end saying a bull also includes a cow. And he said, this is just nonsense. He said, well, yeah, but that's a definition. So exactly the same way, if you have a different set of regulations for calves, particular regulations in calves, you've got to define what a calf is. Now we all know, because we're grown up, that like us, bovine animals mature over a period of time. You don't wake up one morning and say, whoa, it's no longer a calf, it's now an adult. But in law you do, because if you've got a different set of requirements for a calf, you've got to know precisely what a calf is. So it's a bovine animal of 6 months or less. So if you've got it in your shed, you lock it, it's the end of, it was born, let's see, beginning of March. You put it away tonight and it's a calf. Hey ho, you open it in the morning, it's an adult animal. To a scientist, it makes no sense at all. To lawyers, it's absolutely straightforward. I'm not going to go through this. You can have the slides. You'll have the slides afterwards. All I'm trying to demonstrate here is ethical consideration, so far as social policy is concerned, can be really complicated. There can be a huge number of factors that play into it. And although we might wish to give priority to the interests of animals, the politicians who are making the decisions may have many other conflicting, and as they see it, more important issues to take account of. And exactly the same with public policy. One would hope that ethics and law went in tandem, but you know what? They don't always. Here's a little old dog, bring it in, perfectly healthy, want it to be put down. You're my veterinary team, you try and talk me out of it, I say no. So you take it out the back of your consult room, bump into a vet nurse who says, that's a lovely little puppy, and you say, yes, do you want it? And you give it to her. I don't know why I always say her. You give it to the vet nurse, him or her, and they go off into the sunlight tonight and live happily ever after for the next 16 years. Puppy enriching veterinary nurse's life, veterinary nurse enriching puppy's life. You have, of course, committed a criminal offence because you've stolen my dog. It's my property. You can only lawfully do that if I've handed it over. And, of course, if you've charged me for putting it down, you've also defrauded me. Here's a weird thing. Three white mice. Don't know whether they're blind or not, but 3 white mice. One's a feral mouse, one's a companion animal, and one's a laboratory mouse. Up until 2006, that had absolutely no protection at all. Up until 2006, provided I didn't cause that one unnecessary suffering, could do anything else with it. This mouse will die in the end, but to do anything with it, I need 3 separate licenses from the Home Secretary. I can go down to B&Q and buy poisons to put down for this mouse, which if I was using on this mouse would also require 3 Home Office licenses. If this mouse escapes from its cage and goes and lives up in the ceiling somewhere, same mouse, but its legal status changes to being this. Weird or what? And here's an even peculiar one. Rabbits. A rabbit is a rabbit is a rabbit. The degree of legal protection a rabbit has will be entirely dependent on the circumstances in which it finds itself. I won't go through the whole list because I haven't got time. Just to say, I don't know if conjurers still pull rabbits out of hats, but if they do, there's a special law for performing animals. The law's all over the place. Which brings us, and I'm nearly finished, which brings us to the duty of care. It's incredibly important and has made a difference, hasn't it? It has made a difference because it allows enforcement agencies to intervene to put things right. But there are 2 big problems, and they actually come directly back to what Emma was talking about this morning. The 2 problems are this is the offence, what's reasonable in all the circumstances and what is required by good practice. Now, the issue is this, that the courts, to whom it falls to interpret this, will be very reluctant to be radical and make existing practices unlawful through case law, because they will say that that is up to Parliament to do. And when they are testing what's reasonable and what's required by good practice, they will look at the standards of the industry or standards of the activity, which means in terms of dogs, for example, they will undoubtedly look at the bloody Kennel Club as being the standard bearers of the required standard of what is good practice and what is reasonable. Now we know, because Emma's told us, and we knew anyway, that there are serious deficiencies in what the Kennel Club is requiring and promoting. But so far as the courts are concerned, they will be the standard against which other people are judged. So, ladies and gentlemen, it is down to us to keep not only pushing the science and pushing the ethics, but also pushing the law. We need to take on responsibility for what animal treatment. We have to test what is reasonable and what is good practice. And there's another issue in the British system, which again going back to Emma's talk. Up until relatively recently in the UK system, we have not had positive rights. Have the Human Rights Act now, but the tradition is that in Britain we have freedoms and liberties, and that the courts have interpreted as meaning that not for the state, but for individuals and private organisations, anything is lawful unless it's expressly unlawful. You see what I mean? So there's a whole lot of activities, I mean hunting would actually be a very good example, where no one has actually passed a law allowing it. It's just assumed to be lawful because there is nothing forbidding it. And that means, that gives us a challenge, because there's a whole load of things, not least associated with dog breeding, which are despicable unacceptable and an insult to animal welfare and animal ethics. But they are simply allowed because they've never been banned. And I think it comes out of Emma's talk this morning. I did with a PhD student a couple of years ago a big mind map of all the problems of animals, and actually practically everything comes back to breeding and supply. Council of Europe Convention we could still sign up to because that's separate from the European Union. We won't, and do you know why we won't? Apart from the fact it's got Europe in the title, because the Kennel Club are opposed to it. They were opposed to it because it bans tail docking. They were they were opposed to it because they are fearful that it would mean that breeds such as bulldogs would be banned. And the other reason they're opposed to it is, as Emma said, it contains a requirement that a breeder in mating two animals should have due regard to the welfare of the dam and the offspring before the mating takes place. And if there's one thing I would like to see in the law, it is that. It's down to us because they can't speak for themselves. This is a Banksy picture, and you will see that it's the House of Commons occupied not by Homo sapiens, but by chimpanzees. I really should find out the Latin for chimpanzee. You know. Thank you very much. Thank you very much. Oh.